Okay, this is being recorded September 10th, 2025. We are going to be getting into Module 4, which is Maritime Personal Injury Part 1. Before we look at what Part 1 is, let's look at all three parts. There are basically three classes of people who get hurt on ships. And what your remedies are, remember we talked about remedies, the remedies available to you depend on which of those three classes you fall in. The one we're going to talk about today is seafarers. Seafarers have the best of all possible worlds with maritime personal injury because they have all kinds of good remedies available to them. The next class is longshore and harbor workers. These are maritime workers who are not seafarers. They're not seamen. They could be longshoremen. They could be people who go on the ship to do other types of work. They are covered by essentially a workers' compensation scheme. Remember we talked about workers' compensation and why the employee can't sue the employer. You get hurt at McDonald's, you can't sue McDonald's for their negligence, you get workers' comp. Well, these workers have the same thing, only it's a federal workers' compensation plan. It's called the Longshore and Harbor Workers' Compensation Act, LHWCA, and they have only those remedies. They don't get the remedies that seamen have. Now, what's the third class? Everybody else. Everybody else who's not a seaman and not a longshore and harbor worker, get hurt on a ship, you are in that category of everybody else. What does everybody else have? Just ordinary negligence claims, stuff like that. Who would you think is the biggest class of people who sue ship owners for injury on a ship because of the ship owner's alleged negligence? What class of people?
Maybe seafarers?
No, seafarers are in the Jones Act. I mean in the everybody else category. So seafarers, sure, they do. There's a lot of it. But the ones who are not seafarers and not longshore and harbor workers, the everybody else category, what are the most, 99% of the people who sue ships and ship owners who are in that other category, what do you think they are?
I don't know, cruise ship patrons?
Passengers, yes, exactly, passengers. Passengers sue all the time. Passengers get hurt all the time. And down in Miami, there is a whole industry of maritime lawyers who either do plaintiff's personal injury work for passengers or defense work for the cruise ships. Because all of the forum selection clauses, remember we talked about forum selection clauses the other day, all of the forum selection clauses on the tickets of vessels that go in and out of U.S. ports, they call for Miami to be the forum for litigation, either state or federal court in Miami. So the law firms are established down there. I mean, it's big business. It's like, a whole street with, plaintiff on one side and defendant on the other. It's huge. So that's the third category. But today we're going to talk about that first category, which is seafarers or seamen. And they have a lot available to them if they get hurt on the ship. And some of it is statutory, and some of it is judge-made law. Some of it is a little bit of a combination of both. So remember we talked about statutory law versus judge-made law. The seafarer has a whole arsenal of remedies available that have evolved and developed under both of those categories of how law develops. And I had a professor at Fordham who said the seafarer's remedies are like Neptune's trident, three prongs. And so we will look at those three prongs. The first one is called Jones Act negligence. The Jones Act was a statute that was enacted in 1920, a little over 100 years ago, and it gave seamen the right to sue their employers for negligence, right? So then, they wouldn't be covered by workers' comp. They never were. Longshoremen are, but they can sue the employer. So if you get hurt on a ship, unlike most people who get hurt on their workplace where workers' comp prevents them from suing the employer, a seafarer can sue his or her employer. I think we should use seaman as gender neutral, so seaman can sue his or her employer. Anyway, bottom line is that this was an enactment by Congress in 1920 that really changed seafarers' rights dramatically. Because before that, you could get hurt on a ship and basically have very little in the way of remedies. There were some remedies available, and we're going to talk about those other two. But for the most part, it was weak compared to what Congress did in 1920 and gave seafarers the ability to sue their employers. As a bit of history, I will tell you that this was done before that for another class of workers, railroad workers. America was built on railroads in the late 1800s, and what happened was railroad workers, very dangerous place to work, right, on the tracks and on the trains, they were getting horrible injuries and not being able to do anything about it. So Congress passed, I think in the late 1800s, the Federal Employers' Liability Act, which gave railroad workers the ability to sue their employers. Around just after the turn of the century, there was concern that seafarers should have that same kind of remedy, and so Congress did that in 1920, and it basically built on the Federal Employers' Liability Act. So if you look at cases under FELA, Federal Employers' Liability Act, they will actually be persuasive authority on cases under the Jones Act. Obviously, the two have evolved separately in the courts, there's case law on each one, but if you have a Federal Employers' Liability Act case from 1895, and it happens to be good for you in a Jones Act case, the courts will be persuaded because they're similar situations. So anyway, what happened is that seafarers gained this big advantage if they're hurt in 1920, and it's carried on to the present day. We're going to get back to the Jones Act, but now I want to talk about these other two remedies available to seafarers. This one, maintenance and cure, has been around literally for 1,000 years. Because it began with these Mediterranean sea codes in the 1st century CE that were, some of them were actually written down, on tablets sometimes, and there was the tablets of Amalfi, which was from a city on the Italian coast, and it was a center for trade, and these codes were written down, and seafarers, and it was a lot of maritime law, not just seafarers, commercial transaction stuff too. There was the Rolls of Oleron, another one from France, but these codes from the 1st century actually contain a lot of this law that we still use today that we consider judge-made law, because it got passed down, from the Mediterranean Sea Codes, the English Admiralty law, came to the United States and became part of U.S. Admiralty law. So maintenance and cure is not coming from any statute. It comes from ancient doctrines, and the idea of maintenance and cure is pretty simple. If a seafarer is hurt in the service, while aboard the ship or while in the service of the ship, could be ashore, they are entitled to these two things, maintenance and cure. Maintenance is basically just a daily allowance to, have a roof over your head and food. So, it's not much, but it's something, and you're entitled to it if you're an injured seafarer. And that's still the case in American law. There's no statute, but it's judge-made law, and it's solid. Seafarers have that right. And the cure is basically medical care. So if you are injured on the ship, you get the ship owner to pay for your medical care up to the point of maximum recovery. That's a hotly disputed item. When is maximum recovery? Do we keep doing more, or is it good enough to stop here? But the bottom line is you're entitled to both of those things. Now, for American seafarers today, maintenance and cure is not a big deal, because I think, Richie can tell us, the unions have pretty good medical care, and you got money coming in, so it's not the worst thing. A maintenance cure is just a little icing on the cake. But there are still situations out there where you could be hurt on a vessel where it's not a union job and it's a little fly-by-night outfit, could be a fishing boat, could be somebody's little operation, and maintenance and cure can come out of the owner's pocket, and it might make a significant difference. Even if it's $50 a day, and medical care, if you don't have any coverage, it could make a big difference, and the seafarer is entitled to that. So those are the first two on Neptune's Trident here that the seafarer is entitled to. The last one is also an ancient doctrine, and it goes back, I'm not sure if it goes back to the Mediterranean Sea Codes, but it certainly goes back to England, and it's called unseaworthiness. So if a vessel has an unseaworthy condition on board, and that causes the injury, you can sue the vessel for unseaworthiness. You actually don't sue the owner. Under the Jones Act, you sue the employer, which is not the vessel itself, but they're probably related to the vessel. Maintenance and cure, you can go after essentially both, the owner and the operator and the vessel. Unseaworthiness is purely an in rem action. We talked about this in Module 1. In rem means against the vessel, in this case, right? The vessel is actually defended. So if you were going to bring an unseaworthiness action as part of your triple attack here, you would name the vessel in rem, and you would assert an unseaworthiness claim against the vessel. What kind of things can lead to unseaworthiness? You know, slippery surface on a ladder, actually even a crew that is poorly trained and you get hurt because the crew is poorly trained, you can consider that an unseaworthy condition. Most of the time, it's sort of an extra, because if you have Jones Act negligence, the unseaworthiness is just, you know, it's kind of duplicates, because whatever negligence caused that, it's going to be the same. But sometimes the unseaworthy condition can be not due to the owner's negligence. The owner didn't know about it, had no idea, but you can still recover for the unseaworthiness. So you could have, I'm trying to think of an example, oily rag on deck, right? And it wasn't anybody's negligence. It fell out of the engineer's pocket and you slipped on it. And if you can establish that's an unseaworthy condition, even without the negligence of the owner, you can recover for that injury you got falling on the steel deck. So unseaworthiness is not a throwaway. It could be a valuable part of the lawsuit for the plaintiff, right? But it doesn't necessarily matter every time. Sometimes the negligence is going to be the main thing. But occasionally, the unseaworthiness will be not due to the negligence of the owner, and in that case, it could be a very important thing. One thing to remember about this, and here I'll quiz people. If it's an in rem action against the vessel, can you bring it in state court? How many people say yes? How many people say no? No is the answer, because in state court, you can only seek the remedies that a state court is competent to give. And a state court is not competent to give remedies in rem against the vessel. It can't arrest vessels, it can't enforce maritime liens. So technically, an unseaworthy action can only be brought in federal court. I think occasionally people put them in the complaint in state court cases, in Jones Act cases, because either they don't know or it's just their boilerplate complaint that they have drafted for every case they bring. But a lot of Jones Act cases do go in state court. The Jones Act itself says that you're entitled to bring it in state court, and it also says that even if you bring it in federal court, you're entitled to a jury. I believe it says in federal court you get a jury. Yes, you do. I have to think about that for a second. Remember, most of the time in admiralty cases in federal court, the judge decides both the facts and the law, and you have no jury. It's what's called a bench trial. However, the Jones Act expressly provides, A, that you can get a jury, and B, that you can go in state court if you want to. So if you go in state court on a Jones Act case, and you're going to bring your Jones Act maintenance cure, that's fine. Technically, you can't bring the unseaworthiness action in state court. But again, it doesn't matter most of the time as long as you've got the negligence. If I had a case that involved an unseaworthy condition that was not due to the negligence of the owner or operator, I would be very reluctant to go into state court because I might lose everything. So I'd be more inclined to go in federal court and make sure I have that unseaworthiness claim in rem against the vessel. But that's a nuance, okay? Why do you suppose plaintiffs would want to go in state court as opposed to federal court for a personal injury claim? Anybody? Any good reason to go into state court as opposed to federal court? Why would state court sometimes be better? Bear in mind, you're getting a jury either way. You can get a jury in federal court or a jury in state court. But the jury pool is different, right? So, in other words, the people who are going to serve on that jury in certain state courts where it's like Borough of Kings or Borough of the Bronx, or I should say County of, you might get a better jury pool. There has been, I think historically, a feeling that Bronx and Brooklyn juries are very sympathetic to plaintiffs. You got people who are working people who suffer and work hard, and they're, you know, if you have a plaintiff in one of those venues, you're liable to get a higher jury award. Whereas if you, let's say you had a case that was here in the Bronx, right? Seafarer lives in the Bronx and was injured, and you're deciding, do I want to go into state or federal court? Well, if you go in state court, you can get a Bronx jury pool, and you might get a better chance of a higher verdict with that Bronx jury pool, as opposed to going in the Southern District of New York, which takes its pool from, you know, all of the district, which includes Manhattan, and you got, you know, stingy stockbrokers on the jury if they serve. You know, you got people who aren't too amenable to giving money. Obviously, that's just a matter of statistics and generalizations. The individual jury is going to be different in every case. But if you are a plaintiff's lawyer doing this, the very fact that you bring it in state court where there's perceived to be a good jury pool will help you settle the case better, because the defendants will know, well, it's in the Bronx and we're going to have a Bronx jury, or it's in Kings County and we're going to get a Brooklyn jury. So there is an advantage tactically to bringing it in state court if you can get into the county you want. And again, within the 5 boroughs, I would say the best are, or historically have been Brooklyn and the Bronx. Queens, not so much. Staten Island, not so much. Manhattan, not so much. So if you have a Jones Act case and you go in state court, that would be your better option. So let's review just this part, which we're not going to see again in Module 5. We're going to be focusing on those other two groups. This is only about seafarers. This is only people who are entitled to be considered seamen under the Jones Act. And generally speaking, with some exceptions, it's the same population of workers that get this and this and this, okay? In other words, if they're Jones Act seamen for purposes of the Jones Act, they're also entitled to maintenance cure, and they're also entitled to the unseaworthiness claim. That's a given. If they fit here, they also get these two. Now, there is a little bit of wiggle room. There is one class of people who, at least in this district, can get benefit of the unseaworthiness claim, even though they're not seamen connected to the vessel, and they're not longshore and harbor workers, but they do board the vessel when it comes into port and disembark when it goes out, and they are up on the bridge doing very important work. And if they get hurt on the ladder going up and down, they can use this remedy if that ladder is unseaworthy. Who am I talking about?
Pilots?
Pilots, exactly. So we've had a death within the last 10 years in Sandy Hook Pilots Association. We've had major injuries that required multiple surgeries. When one of the pilots fell from the ladder onto the steel deck of the pilot boat and injured his feet and legs very badly. It's a very dangerous job because of that one aspect, boarding the pilot ladder. In fact, I have a short film I'll put a link on Brightspace, and you can watch that, and it talks about pilots, what they do, and the risks they take. But pilot ladders can be extremely dangerous. Remember, you get a pilot boat, you can rely on, right? If you're a pilot, it's your association's boat, and you can rely on them to hopefully do a good job getting you out to the ship, or picking up, as the vessel is leaving. But the ladder is rigged by the vessel personnel. And you have absolutely no control over that. You're relying on them to do the job right. And if they mess it up, you could get hurt or killed. And it's a serious problem. And it's always been a serious problem. And it isn't showing any signs of getting any better. I mean, there might be some technology that we could get to, but what are you going to do? Drop the pilot down from a helicopter onto the deck? I mean, it gets kind of expensive and extraordinary to do that. The pilot ladder, if it works right and if it's safe, is really the best way to do it. But remember, in heavy seas, and if the pilot ladder has a defect where, it suddenly gives, that was one case, it was rigged and then it just kind of dropped 2 or 3 feet and the pilot was thrown. It's very dangerous. But anyway, to get back to the point of tangency, it is the case here in the Southern District of New York that the federal courts recognize that pilots are entitled to unseaworthiness. They are not seamen for purposes of Jones Act negligence, and I'll explain why in a little while. And they don't also get maintenance and cure, but they are entitled to recover against the vessel in rem if the pilot ladder was unseaworthy, which has happened, and there's, I can think of a couple of cases that have happened within the last few years where that was applied. But now, getting back to the main group here, not pilots, but seafarers. What makes somebody a Jones Act seaman? They call it a Jones Act seaman. What makes you a Jones Act seaman? What do you have to do to be in that category? You got to have a union card. You have to go to Maritime College. You have to have a Merchant Mariner's document. What do you think? Anybody? What do you think the criteria are to qualify for that? Anybody? Okay. I'm just asking you to guess, really. You don't actually have to have credentials. It's what you do on the vessel that matters. It used to be, before, I'd say 1991, that, at least in the Second Circuit here where we are, to be recognized as a Jones Act seaman, you had to do the salty stuff. You had to hand reef and steer. You had to, you had to actually do maritime kind of work, right? That's been changed, and the Supreme Court in 1991, in a case called Weilander, unified the doctrine nationwide. And the idea is that if you contribute to the mission of the vessel, you're a seaman for purposes of the Jones Act. Now, that's very important for certain people in certain jobs who don't do anything salty. Best example would be a musician on a cruise ship. The mission of the vessel is to entertain passengers. The musician entertains passengers. Therefore, the musician is a seaman for purposes of the Jones Act and is entitled to all these benefits. So if you're a guitar player on a cruise ship and you get hurt because of the vessel's negligence, you can sue as a Jones Act seaman, and you've got all those benefits. Before 1991 in the Second Circuit, you would have been out the door. If you could sue down in the Fifth Circuit back then, you would have gotten it. That's down in Louisiana, Texas. I think I showed everybody that diagram the other day of the circuits. But the bottom line is it's unified now, and the standard for becoming recognized as a Jones Act seaman is whether or not you contribute to the mission of the vessel. Well, that's one of the standards. There are other tests that are required. You could walk on board and contribute to the mission of the vessel and leave, right? The pilot does that. I point to this because the pilots have that. A pilot contributes to the mission of the vessel, if the mission of the vessel is to transport and you have to move and dock for that, and the pilot brings it in and takes it out. But they're not permanently attached to the vessel. The other requirement for seamen, one of the other requirements, is there has to be a more or less permanent attachment to a single vessel or a fleet of vessels from the same company. So if you work as a deckhand on 6 different tugboats owned by McAllister, and you rotate among them, you're still a seaman even though you're not attached to one in particular. But it has to be an attachment to the vessel. You can't be somebody who just walks on, does the job, walks off. You have to have a more or less permanent attachment to the vessel. Now there's a little wiggle room in that, and a lot of litigation has come out of, well, 40% of the time he's on the vessel and the other 60% of the time he's ashore, and how much matters, But the bottom line here is, to be recognized as a Jones Act seaman, you have to contribute to the mission of the vessel, and you have to have a more or less permanent connection to a specific vessel or a fleet of vessels, okay? So an example of that, a very important case, Latsis v. Chandris, also in the 90s. Antonio Latsis, he actually used to go to the Maritime Law Association dinners, even though he wasn't a lawyer, he was kind of a celebrity. Latsis was an engineer who served on a fleet of vessels owned by this Greek company, Chandris. And he did not have an attachment to one vessel, but he was on board doing, kind of oversight of engineering situations on all the vessels, and he would rotate among them. I believe it was a passenger vessel. He wasn't a passenger, he was an employee, but he worked for the company, and he was an engineer, and he had a more or less permanent attachment to this fleet of vessels. So what happened to Latsis is he went on this passenger vessel, and this is something you got to be careful about if you make the cruise and you have a doctor telling you something. Sometimes these doctors on ships are a little quacky. And so this doctor examines Latsis, who's losing his visual field. He's starting to see, darkness closing in from the sides, at least in one, I think it was just one eye. And does anybody know what that might mean if you start to lose vision in the periphery? Detached retina, very emergent condition. I mean, you want to be in a hospital very quickly and get in and get surgery to stop that detachment from spreading, because you're going to lose more and more vision. Yes?
Glaucoma?
No, glaucoma is different. Glaucoma is pressure in the eyeball that squeezes on the retina so hard that it damages. A detached retina, the retina is actually coming off the surface, and it's like the photographic film that's supposed to be attached, like an electronic photographic film, is now coming off of the interface, and it can be reattached up to a point, but it's kind of thing, once it starts, it tends to come off more and more. And so if you wait 3 or 4 days before you're seen, you're going to lose a lot of vision. So Latsis was told by the doctor that, you don't need to go ashore now and get it taken care of. You can just ride the ship, and down in the Bahamas or whatever the next port was, you can see a doctor there in 3 or 4 or 5 days, right? So he lost most of the vision in one eye as a result of this bad medical advice from the ship's doctor. And he sued, and the big issue was he a seaman for purposes of the Jones Act? And it went, I believe that went all the way to the Supreme Court too, and they found yes, he did, because of that more or less permanent attachment to the fleet of vessels. Even though he wasn't, attached to one vessel, he was an employee of the company, and he regularly rode on different ships within the company's fleet, and that was enough to be a seaman for purposes of the Jones Act. Because if he hadn't been, the negligence of the doctor, that imputes to the owner, right? The doctor is the owner's employee, so that would be a way to get a negligence claim, but he'd be much better off to do it as a seafarer than in some broad category of non-seafarers. The stuff we're going to talk about tomorrow, not tomorrow, but next module. So the whole thing here is that obviously if you're going to get hurt on a ship, the best one of those 3 categories to be in is being a seaman. Then you'll get Jones Act negligence, maintenance and cure, and unseaworthiness, the Neptune's trident there. If you're in the other categories, you don't have all those benefits. Plus, the negligence standards under the case law are very favorable to seamen. In other words, seamen don't have as much duty to look out for themselves as other people do. The case law basically gives seamen a lot of leeway in being a little bit careless, and then the vessel is supposed to take care of them. You know, there's some limits there. You can't, you know, do something terrible and really super negligent and still recover, but you can contribute a lot of negligence to your own injury and still recover hundreds of thousands of dollars from the owner. You can do pretty stupid things. And it happens all the time. And of course, owners don't like it, but it really doesn't come out of their pocket. When we talk about marine insurance, we'll talk about P&I and how that interfaces. How are we doing for time? Let's stop the camera for a moment and just have a discussion.